Hello and welcome to this podcast from members of the Brexit team at Eversheds Sutherland. I'm Tom Bridgford and today I'm joined by Sara Ellis. Before we begin, can I quickly draw your attention to this disclaimer? This podcast is the latest Eversheds Sutherland Brexit update. Even as we record this podcast, political events are moving at high speed. Whilst we can't predict political outcomes, what we do know is that the government remains committed to leaving the EU on the 31st of October, and that the agreement of all 27 EU member states, as well as the UK, will be required in order to extend that date. The purpose of this podcast is to talk about planning for no deal. When we talk about a no-deal Brexit, what we mean is that the UK leaves the EU without there being any further agreement between the UK and the EU on the terms of the UK's departure. There would be no transition period or agreed continuation of the status quo. The focus of this podcast is for us to give you some of our thoughts on what we think the priority areas are for life after a no-deal Brexit. We should frame our decisions and our planning for future business cycles with a view to the new regulatory environments that will need to be introduced and which will affect us all. Going forward, I think the key is that the UK still has to build a new relationship with the EU, and we can't predict how difficult or easy those negotiations will be, although I think we can say with some certainty that they won't be quick. And we can say that the UK has to adapt to the new reality of being a third country, and that means it putting in place new policy frameworks for a variety of issues, the most notable from a commercial perspective being trade and immigration. We don't know how much time this will take in Parliament and whether that means that other programmes the government wants to develop will be pushed down the queue. In terms of the development of these new policy framework, there's an interesting conundrum. Although the 2016 referendum delivered a result, it didn't deliver any kind of clarity on how the contradictions of Brexit will resolve. It seems that many people voted for Brexit because of the argument about taking back control, being that of our borders or of what laws we pass. But the conundrum is, will the UK really have total control of its destiny following Brexit? Once the UK loses full access to the single market and the customs union, we'll have to be open to trade with other countries, and free trade may mean compromises for our own regulatory environment. If we're planning for the future, in some way we need to take into account these inherent contradictions. I'm now going to hand over to Sara, who will talk about a recent report on preparations for no deal.
Thanks, Tom. So the report that Tom's just referred to was issued by the Institute of Government back in July, and it outlines what it thinks the government needs to do both before the date of departure from the EU and after that date, and it included various key findings. The first one is that key Brexit bills don't need to be passed prior to the 31st of October, and they can be brought back after the UK has left the EU. But this will leave EU law frozen into UK law in key policy areas, with very limited powers to make changes. So the vital point here is that no further legislation is needed for the UK to leave the EU. Under international law, we'll be leaving on the 31st of October unless something is legislatively done to stop this. Remember, the UK Parliament has already passed the main bill needed for Brexit, which is the European Union Withdrawal Act. This provides for legislative continuity on day one of exit, and it also repeals the effect of the EU treaties within the UK. The government's already signed the necessary regulation for this repeal to take effect on exit day. Now, originally, the government said that there would be another 10 bills needed to manage the domestic impact of no deal. And whilst half of these have been passed, others which set out the new policy frameworks after Brexit have not. And these include bills on immigration and trade, as well as a financial services bill, which allows the UK to stay aligned to EU financial services legislation. So the European Union Withdrawal Act and all the statutory instruments issued under it should ensure there are no significant gaps in domestic law on day one, but failure to pass the rest means no new policy frameworks exist. On the day we leave the EU, UK law is essentially frozen in time until Parliament passes new laws. The next point raised by the report was that new legislation will be needed to introduce direct rule in Northern Ireland if the Northern Ireland executive hasn't been restored by exit day. And that's relevant if the numbers in Parliament mean that it can be blocked by the opposition parties and rebel Tory MPs. It also notes that emergency budget may be needed, and that after exit day the consequences are highly unpredictable, and it's unlikely that a managed no deal or any side deals to soften the impact will be accepted by the EU. Several deals with non-EU countries will be lost, and we'll look later at what is happening with existing free trade agreements that the UK currently benefits from. The Institute for Government suggests that the government may have to support struggling and failing businesses, and the Chancellor of the Exchequer has indeed announced some support, but only for businesses that fail, not businesses whose operations need to be reduced in order for them to survive. And in addition, there'll be increased pressure on the Union from both Northern Ireland and Scotland. If we look at the side deals point, both the UK and the EU have already taken unilateral action on a time-limited basis for a no deal in areas where the biggest impacts may lie, such as an interim permissions regime for financial services and action on aviation to ensure that flights can continue. There's been no coordination between the EU and the UK on these unilateral measures. And in any event, the unilateral temporary measures the government is putting in place only push out the problem to another day, and they don't match the planning cycles of the private sector, which can be for 3 to 7 years. Now, it's important to keep in mind that the unilateral actions that both the UK and the EU have taken to lessen the impact of Brexit are time limited, with the maximum period of their application being between 9 and 12 months. And they're just there to lessen the impact of a disorderly Brexit. They're temporary relief measures, not new policy frameworks. And we also shouldn't forget that a no-deal Brexit means that the withdrawal agreement that Theresa May's government negotiated will be officially dead on the 1st of November, and that means no transitional arrangement will apply. The UK can then start to negotiate a future trading relationship with the EU, but whether the framework of terms that was agreed late in 2018 will still apply to those negotiations, I don't know, because no one's currently bound by that framework. And the final point on this slide is also important. Article 50 was designed to allow a smooth exit, requiring only a qualified majority of EU member states to agree the withdrawal agreements for the UK's exit. Following a no-deal departure, Article 50 is no longer relevant. It's likely that unanimous support for new arrangements with the UK will be needed outside the Article 50 process, and that means the risk of the UK being held hostage to the demands of one member state. It would also need a majority in the EU Parliament and then ratification by national and in some cases regional parliaments in the EU. And Tom's going to talk to you now in a bit more detail about the UK's no-deal planning.
Thanks, Sara. Earlier this year, the UK government put in place operational plans for our exit, which were then stood down. The government under Boris Johnson has made it a priority to put these plans back, but remember, they cover only how to resolve issues as they arise, rather than preventing them occurring in the first place. The contingency planning relating to trade in goods involved the UK publishing a new and temporary no-deal tariff schedule back in March. This was designed to apply only for a period of 12 months, whilst a full consultation and review of the UK's permanent approach to tariffs was undertaken. Under this temporary regime, 87% of total imports to the UK by value would be eligible for tariff-free access. But this is only for imports into the UK, not for exports to the EU, which would be subject to the EU's own tariff schedule that applies already to non-EU member states. For customs, the government is putting in place a new customs declaration service, and that should be fully up and running by December, but not by October. On the issue of the Northern Ireland border, no information has been shared by the government on this other than some temporary high-level measures. So, for example, Theresa May's government said it would not introduce any new checks or controls on goods on the land border, and the temporary tariff rates that would apply to imports into the UK would not apply to goods crossing from the Republic of Ireland to Northern Ireland. Whether this position will change depends on how the positions of both sides on the Northern Ireland backstop develops, if at all.
Thanks, Tom. Another key issue is the status of the current free trade agreements that the EU has negotiated with other countries and which the UK currently benefits from as a result of its membership of the EU. The latest update from the House of Commons Library references that these EU agreements are expected to no longer apply to the UK on a no deal. The UK government's aim is to negotiate new deals with these countries to provide for continuity, and it has managed to sign some of these new deals already, but they tend to be with smaller economies such as Chile, Eastern and Southern African states, but not South Africa, Switzerland, Israel, Iceland and Norway. It has managed to roll over the trade agreement with South Korea, and that is a more significant success. They've also confirmed that free trade agreements with Japan and Turkey will not be rolled over by exit day. Canada has said it won't roll over its trade agreement, in part because the UK's proposed no-deal temporary tariff schedule, which zero rates most products, mean it's simply not worth it, as Canada gets zero tariff access to the UK in any event. But it's not just full trade agreements that are at stake here. The EU has other agreements with third countries, and several hundreds of these have relevance to the UK. These cover cooperation on trade, aviation and nuclear, for example, and they will also cease to apply to the UK on a no deal. Now, the UK has already negotiated continued access to these, particularly in the field of aviation. Staying on the theme of future free trade agreements, the UK government's been consulting on this, and the position seems to be that trade negotiations will be prioritised for the USA, Australia and New Zealand, with membership of the Trans-Pacific Partnership also up there on that list. Neither India nor China appear to be a priority. And what about the content of these new trade agreements? The government has published summaries of its recent consultation with a view to developing an independent UK trade policy, and this slide summarises some of the findings, but remember, this is just a wish list. New Zealand and Australia, which are key target countries for UK trade policy, may decide that an EU trade agreement is more of a priority for them than a UK deal. And the process needs to take into account that terms agreed in these proposed free trade agreements shouldn't compromise or negatively impact the terms that the UK wants to agree with the EU. I'm going to hand back to Tom now, who's going to talk about some of the key areas in which a no-deal Brexit may impact on commercial contracts.
This slide summarises some of the key issues that a no-deal Brexit raises for businesses from a commercial contracts perspective. First, pricing and the risk profile of the contract. Do the assumptions on which the pricing was made remain true? What increases in costs will there be, and which party bears the risk of these? Linked to risk profile is ensuring that agreements that relate to particular territories continue to work after Brexit. So if you've got agreements that define territories, for example, for sales or licensing of rights, then references to the EU or the EEA need to be checked to see if they're intended to include or exclude the UK. Trade in goods. There will be tariffs on goods exported into the EU. You should be considering which party will bear these. If you're contracting using Incoterms, is the chosen term still fit for purpose, bearing in mind the new tariffs regime and customs formalities? For services contracts, whilst tariffs don't apply directly, trade in services is sensitive to non-tariff barriers. Workforce. Brexit means no more freedom of movement, which of course impacts on worker mobility. The EU has stated that decisions in respect of UK citizens in the EU should be left up to individual member states, rather than a decision being taken at EU level. In the UK, the government has passed legislation to allow EEA and Swiss nationals and their family living in the UK before Brexit to continue to stay and work in the UK, and other EU member states have offered similar rights. For businesses that rely on current EU-wide regimes that recognise professional qualifications, certain UK professionals selling services abroad will no longer be able to access certain professional markets in the same way, but will have to apply different local rules in each EEA state. Compliance with laws and regulatory compliance. There will be increased burdens when the UK loses the framework for mutual recognition. Businesses will need to understand the regulatory regimes that apply to them following exit day. For example, will they need to comply with both an EU and a domestic regime, and will these be divergent? This doesn't just apply to sector-specific regulation, but also to for example, compliance with consumer laws and product safety rules. Data. For the purpose of GDPR, the UK will become a third country on a no-deal Brexit. So if you transfer personal data to or from an EU country, you will need to ensure that you have adequate safeguards in place to protect those data flows. IP. Businesses should consider whether their IP portfolios are adequately protected following Brexit and the pan-European regime ceasing to apply to the UK. Corporate structures. For international businesses, are your existing corporate structures still fit for purpose, or is a reorganisation required? Litigation strategies. Do you need to change your dispute resolution or litigation strategies? And the final, but by no means least significant point that I want to make on this slide is that we need to factor in the risk of an economic shock. And how do we assess how large that shock might be? If your counterparty's financial covenant is weakening or its business model is under threat, how does that follow through to impact on your commercial arrangements? A couple of other points just to mention, because there are a host of issues to consider when looking at contracts, including how do you define Brexit and what might be a Brexit trigger? What's the impact of delay on the contract? How would you define force majeure? How are you dealing with currency fluctuations? And what are you doing in relation to jurisdiction clauses? We're also seeing many clients adding Brexit continuity clauses into their agreements with suppliers. So there's a lot of issues to consider in relation to contracts. That brings us to the end of this podcast. If you have any questions or would like to discuss any of the issues that we've covered, please don't hesitate to contact one of us or your usual Eversheds Sutherland contact. Thanks very much for listening.